And you are here with the Mavericks and Abbie Clement. Hey, how are you all today? Let us know by putting in a comment telling us whether you're with us live or if you are watching the replay. So if you're live, give us an emoji. If you're watching the replay, type in the words replay. We would love to know what you're up to. Also, if you could do us a massive favor, why not share this stream and join lots of other people? We are going to be talking about protecting your business. We're going to go into privacy laws, and Abbie is here to do a presentation and to learn us good and proper, as well as to show us a demonstration. And she is here for you to answer questions that you may have. So if you have any questions along the way, please feel free to ask those questions in the comment. One of us Mavericks or one of the Cloudways team will make sure that your question is presented to Abbie to give her an opportunity to give you some immense value. Before we jump into the presentation, though, it seems wise for us to go around the room and introduce ourselves. So let's start with Picha today. Picha, give us your 30-second intro.
Hello, my name is Picha Neri and I am a UX and design expert, and I'm a Cloudways Maverick, just like my wonderful colleagues Lee Jackson and Jan Koch. And I can't wait. I use Ubender, and I can't wait to hear from you how to use it properly so that I am safe. So I'm really looking forward to today, Abbie. Thank you for being here.
Jan, your turn.
Yeah, I'm Jan. I'm also a Maverick together with my beloved colleagues, and I host the WP Agency Summit that's coming up in October already.
Whoop, whoop. Abbie.
Hi guys, I'm Abbie Clement. I'm head of content at Ubender, and I'm just happy to be here to talk to you about the most exciting topic in the world, data compliance. Everybody must be jumping out of their seats.
Absolutely. And my name is Lee. I'm the host of the Agency Trailblazer podcast. You can check that over on agencytrailblazer.com. Remember, folks, if you have any questions during this whatsoever, please let us know. Abbie is awesome, and she'll be happy to share, like she said, on the very exciting subject of data compliance, etc. So, Abbie, without further ado, if you'd like to share your screen, and let's get cracking.
All right. So let me just set that up here.
No worries. Should play some holding music, shouldn't I?
Some elevator music.
Lift music would be the best. There we go.
So I'm just going to go into presentation mode.
We'll all go on mute and we'll keep our eye on those questions.
Okay, great. So what we're going to do today is we're going to try to just do a really quick overview of maybe the most important data compliance laws, you know, the popular ones, but also the ones that you might not know by name, but that obviously really impact what you need to do for compliance with your website or app. So we're just going to jump right ahead and really quickly, just a quick shot of what we do at Ubender. So we have over 60,000 clients in over 100 countries, and they use our software and also direct assistance that, depending on your needs, to meet data compliance requirements, and which obviously can be a little bit difficult from a legal and a technical point of view. Can involve lawyers and all of these things. So we have our international team of lawyers that work on all of our legal texts that we use in our product, and we try to make it as easy as possible, kind of facilitating this whole thing with technology, to kind of just marrying all of that legal stuff with the tech to solve these problems. So I'm going to just jump right ahead, and we're going to look at what are the existing privacy laws right now with the biggest impact. So generally, we'd say that would be the GDPR. Everybody's aware of that one. There were tons of emails going out around that time, which is live and in effect, and you need to comply with, as well as the ePrivacy, less well known by name, the CCPA, and CALOPA. And CCPA was also quite a bit of a topic in recent times. So we're going to just do a quick overview of these to make sure that you know the important points. So let's just dive ahead first into the GDPR. Now, at its most basic, the GDPR, which is the General Data Protection Regulation, it tells you how and when, or it specifies how and when data should be lawfully processed, personal data. Now, personal data can include anything from IP address to emails, names, biometric data. basically any data that can be used to identify a living person directly or indirectly. So this can also relate to pieces of information that if you patch it together across various sources, you can also identify a person. So it gets a little bit tricky. Now, under the GDPR, personal data can only be processed if there's at least one legal basis for doing so. There are 6 legal bases. I don't want to go too much into all of the legalese in this presentation since we have so much to cover. But of course, you know, some of the most popular ones would be something like consent. But there are a few other legal bases that apply. Most of them kind of really depend on circumstances, but there are some, like, let's say some companies choose to rely on legitimate interest, or something like contractual obligation, which is where you're processing the user's data in order to fulfill a contract that the user is already a part of. So they want to purchase your services or whatever, and you need to process their data in order to fulfill your end of that deal.
Would legitimate interest be termed as, I have a legitimate interest in selling you something, you probably have a need for this, so I can connect with you in that manner? Is that the sort of legitimate interest you would mean?
Yeah, so what I was describing before was contractual obligation, but legitimate interest is a bit more fluid. It can be used in this way, but something to be noted with legitimate interest is that it's a legal basis that can be like instantly struck down by the user, kind of enforcing their right to object, right? And it should be justified as well. So that leads to the next point, which is that you shouldn't just pick legal bases at random. They have to actually apply legitimately to your situation. And it's really important because this is one of the few things that's explicitly stated. I can't recall the exact article under the GDPR right now, but it's explicitly stated. So, you know, you can expect the data protection authorities to be especially hard on people that are applying or using legal bases that don't legitimately apply to their situation. So this is a big part of the reason why in many cases, just for your everyday processing of websites and so on, many people choose to rely on consent, where something like, let's say, contractual obligation doesn't apply. The fulfillment of a contract.
Abbie, can I just ask you, do you have a legal background?
My background is in tech, but being involved in just sort of having to write all of the guides and so on, explaining the law in a way that users can understand.
You're not an expert.
Well, somehow I rely on the actual experts, which is our lawyers. So I work with them closely on all of the guides that we put out. We put out a lot of guidance because a lot of our job is first educating people. It's such a complicated topic, and the information is really hard to find in a straightforward way. So actually, maybe my expertise is in not being a lawyer, because I then have to understand it from the lawyers and try to, make it understandable to average everyday people like me, like you. So I hope I'm doing a good job, but of course I'm not giving any kind of legal advice, and nothing that we say here can be considered one-to-one legal advice.
Yeah, makes sense.
Moving on to the ePrivacy. So that was just a really quick overlook at the GDPR. Now I'm going to get into where it applies, if it applies to you, how to tell, all of this kind of stuff. But first, I'm just going through really quickly these laws. Now, the ePrivacy, or the informally known as the cookie law, it's been in effect since 2002. It's a directive, and it guides electronic privacy, including email marketing, cookie usage, and so on. Now, just quickly say something about the word directive here. So a directive, you can think of it as, it's not quite the same as the GDPR, which is a regulation. So with a regulation, you have, let's say, one standard law, more or less, so legislation applying in the same way across all of the EU member states and in all the cases where it applies. With the directives, it's sort of like, we can think of it as being like a guidance, and then each one of the EU member states they can choose how to implement it. So then you have multiple individual laws that might change little specifics and so on as it relates to the use of cookies. And actually, we're putting out, we have available, and I might link to it in your notes, a huge cookie table that actually lists, it's like just a resource that lists all of the different cookie laws from the EU member states. There's slight differences. Some member states are more aligned with the GDPR. Some are still a little bit behind. So for example, with Italy, you can still give consent in some cases by scrolling. In the UK, you cannot. The user has to consent explicitly by clicking I accept. So in this table, we sort of explain all of the differences and compare it. So I'll leave that link.
I do. Sorry, and again to interrupt.
No, go ahead.
For so Cloudways, we do have also a large US audience as well. So obviously, huge EU audience and a huge US audience, and often there would be the assumption that this may not apply to a US company. Is that an incorrect assumption? I've heard that
absolutely is an incorrect assumption. It depends. So, okay, I'll actually touch on it really briefly since we're talking about it. So, for example, something like the GDPR applies if, in one case, if you have EU-based users, right? Regardless of where you're based, if you're in the US, you're in China, wherever you are, if you have EU, you're processing the data of EU-based users, and again, even IP addresses can be considered this, you're subject to the GDPR. But then it also applies the other way around, which is important to note because there are some EU-based companies that only have US users, for example, but they're not exempt from the GDPR either, because if you are based in the EU, then you have to extend GDPR protections and the GDPR applies to you. Also, if you have a subsidiary, so your business isn't, you have a subsidiary of your business based in the EU, then the GDPR also applies in this case as well. And that's just the GDPR. If you're looking at stuff like Californian, the CCPA, Consumer Act, this also applies in a similar way. They protect Californian consumers, whether you're based in California, in the US at all, or in the, within the EU or whatever. So it's really important to be careful here because a lot of these laws apply regardless of where you're based. And when you get hit with a nasty fine or a lawsuit, then it's not.
Thank you. That's really helpful. Just to kind of set the context for the wider audience, because often people think, oh, it's EU GDPR, I can ignore this. So thank you.
Yeah, it's good to know. And consider that there are a lot of laws coming up now that are in line with the GDPR. So the Brazilian LGPD, for example, which we also support. There are various legislations that are now popping up that have been inspired by the GDPR. So it's something to keep an eye out for. Okay, so we actually touched on that point. We're going to just jump ahead. So just to really go quickly over what a cookie is, because it comes up a lot, but it's not always so clear. You can think of it as basically being a small piece of data that is sent from your website or app, and it's often stored on the user's computer via their browser. So the ePrivacy or cookie law requires that you get the user's informed consent before you can run these scripts to install these cookies and track them. And so usually you're required to have a notice or a banner that tells the user, okay, my site uses cookies. Here's why, a link to a cookie policy that gives more information. And until the user consents, you should not run these scripts. Now, even though it's not such a, talking about cookies, most people are familiar with different third parties that might even run cookies. So even if you don't have some technology that you've written yourself into your site, you might just be using a widget. You might be using a login widget from Facebook, for example, or a Pinterest share button or something like that. And these third parties also use cookies. So you need to block all of these until you get consent, or if the user doesn't give consent, then you can't run it.
Is that true for things like Google Fonts too? Like when you load Google Fonts from the Google servers?
So it can. This can also apply. Now there are some exemptions. Again, because cookies fall under the directive, there are some member states that have some various exceptions depending on the type of cookie being used, but by and large, since most of the member states are moving towards this GDPR interpretation, you want to just be careful unless you're actively scanning to block users just from like, okay, I don't want UK and Germany users, but Italian. Unless you're doing that, which can get quite tricky, it's always best to go with like the strictest recommendations, just, you know, to be careful there. And also, of course, with it, wherever you're processing data in your privacy policy and things like that, you need to also declare that you're using these technologies on your site that might be processing data and all of this stuff. So it can kind of vary, and it can vary based on your individual situation, but by and large, this is what you need to think about. And also, cookies can be considered sort of, it relates to the CCPA as well. So for the people joining that might just be in the US, if you might have Californian users as well, don't think that this has nothing to do with you. There is some relevance there, and we'll get into it a little bit later. So we talked about the legal requirements, but I wanted to touch on the industry requirements. So the advertising industry and IAB, for example, the Interactive Advertising Bureau, which is a huge, let's say, collective of big players in the digital ads ecosystem and so on. They're also companies that also need to comply with the law. So they can also face fines and all these things. So when the GDPR launched, there was a lot of confusion, people trying to figure out how to comply on a technical level. And since this is one industry where there's a lot of communication happening between companies, they sort of set up the tech lab to create a solution for passing user consent seamlessly along this advertising chain. So this is relevant to you if you're like a publisher, which is just basically someone that has ads on your site. If you profit from your content by having ads running on your site and stuff like this is really important to know, because in many cases, some advertisers they will throttle, or like they won't show ads on your site, or they might default to non-personalized ads if you're not passing TCF, which is the Transparency and Consent Framework, specific consent to them, so that that's compatible with the network. They can pass that along and say, okay, they got consent, we can show these ads, we can track this person, we can do that. And actually, quite recently, this month, there was a transition from the first version of this framework. Sorry to get a little bit technical here, but it's important to know because it affects revenue. So they've moved from the first version to TCF2, and Google has come on board. Now, Google was always a part of, let's say, on the board of IAB, but they didn't implement their ad network integrated with the framework fully. So now they've come on board, and so it's really, really important to make sure that you're using a content management system that's now passing TCF consent to Google, or else you're going to be faced with, ads not running, or on other networks, non-personalized ads, and your revenue dropping seriously by a huge amount. Which, for an example, there was recently a case we were tagged on Twitter by Snopes. They had various things, but with compliance, they saw that some of their revenue as a publisher had dropped, and they implemented our cookie solution, and they put out sort of some information. We didn't request it or anything, just kind of to let other people know that if you've seen your revenue dip, this could be why. Make sure you're complying, and all the various ways. So that was just something important to note. Now let's look at the American laws that mostly come into play. So California's most well-known privacy laws are some of the most robust in the United States. So we're going to go into these because in the US, because you have, states, you have a case where various states might have various laws. There isn't this overarching framework as such, as with the GDPR. There are some talks that seem to be happening around creating something similar, but I don't have any details on where that's at right now. And there are some federal level laws in terms of like spam emails and so on that we won't really go into here. But by and large, California's laws have sort of led the way in many ways for privacy laws in the US. And then, of course, if you're in the US, you're selling to people in the US. If you have Californian-based users, you need to pay attention to these laws. Now, the first one has been around since 2002, and this is the California Online Privacy Protection Act, CALOPA, which requires commercial websites and services to have a privacy policy. Now, to be clear, privacy policies are more or less required by almost every legislation globally at this point. But this was one of the first acts to, and particularly in the US, to explicitly request this. Now, I'll get into it a little bit later if we have time. What are some of the basic things that a privacy policy should include, the very basic ones, because I guess that some people would be curious and we want to be as hands-on as possible. But in general, you do need to clearly state what information is collected, who you share it with, and sharing it can be as simple as having, again, a Facebook login button on your website or a pin it button or whatever, because this is a third-party service on your site. So you're essentially sharing user data with these third parties.
Is that, sorry to interrupt. So essentially, whenever we load data from a third-party site, that's considered sharing?
Well, not necessarily loading from, but to, because if the user is accessing your site for your service and you're determining, so let's give the idea of the data processor, the data controller, it's you as the website owner. So you are sort of deciding what data you process and also why, right? So for example, if you have a pin it button, it's because you want people to share whatever content on your site with Pinterest, which will require them to log into their account to be able to do that or whatever, as an example. Or like the Facebook login button. So you have your purposes. However, that third party also has their purposes. People log into their account because they have an account there, they sell them ads or whatever. So in this case, you're both data controllers. But on your end, they have their responsibility. They have their privacy policy on their site, which it's good for you to link to. But on your end, the user is interacting with them through your website. And therefore, you're sharing that user's personal information, whether it's their IP address, their location, geolocation, whatever, with that third party on the back end.
So it would be as simple as having sharing buttons on there where people can post my site to Facebook to share it. That's already sharing data that I need consent for.
Well, yeah, I mean, it depends. It's not necessarily saying that you need consent per se, because there's also looking at US laws and then EU-based laws. Consent is just one legal basis. So maybe somebody's accessing your site, they're browsing it or whatever, because they want to, they want to read the information and so on. There's sort of like maybe it's in your legitimate interest, or maybe there's like a contractual situation going on because you're fulfilling something that they're seeking out. However, and it is quite tricky. And again, I try not to give any kind of super legal advice, but do consider that some things might have a heavier weight than others. They're accessing your site, they are sharing their personal data, but they have the right to be informed, both under the US law and EU law. So they do need to know that you are processing their data as they're using their site, and that information typically goes in the privacy policy, which should be easily accessible in the footer or whatever, right? Yeah. So they get informed in that way. However, cookies are sort of another thing, aside from the fact that they sort of fall under the ePrivacy, and that has like specific things. Also, they tend to involve tracking, and that is even stricter. So you need to, more generally speaking, should be relying on consent for that in most cases.
This seems like a silly question, but from everything you said so far, I imagine that 80% of the internet are breaking all of the rules. What's the likelihood that we're going to get prosecuted, or how can we mitigate prosecution, etc.? Because I can imagine, for example, with sharing or certain things, I'm probably breaking a law somewhere, and I'm not sure where I might be breaking it.
Well, I don't think that. I mean, if you're talking about the internet on the whole, as you as an individual, the GDPR wouldn't really, if it's like your
my business. So I've got a business.
Oh,
I've got
your
several
business.
business
Okay.
websites, and in theory, so we've talked. You mentioned Google Fonts earlier. There's lots of different things that I may have cookies for, like Google Analytics. I mean, I've got it restricted so that we don't have identifiable information like IP addresses, etc.
Yeah, so there's some things that you can do, and then also it depends again on where you're based and who your target users are and stuff like that. In the US, it tends to, the laws tend to be more opt-out based rather than opt-in. So you don't need to provide consent, but if you like, if I don't want you to do it anymore, I should be able to opt out. Like in terms of things like the Can Spam Act, so like emails. And then also under the CCPA, it's sort of like this as well. It's also more of an opt-out. You inform me that you're doing it, and then if I don't like it, I should be able to opt out. Except in the case of children, that's opt-in. The thing is that, yes, especially under the GDPR, fines have been handed out. And this is like a little bit of a misconception, because the biggest ones make the news. So people are seeing that, there are $1 million fines to Facebook, to Marriott, to, British Airways, to whoever. However, there are some websites, the info is publicly available. You can actually see all the smaller fines that are being handed out. And they're being handed out to smaller businesses. I think there was one case where like a policeman might have gotten one like a year ago in Germany because data was mishandled. And I don't know about here. Right now, I'm in Milan, and on the ground, if I go to the doctor or whatever, I sign forms. I have to check a button giving GDPR consent for processing.
So it is. I guess that was the main crux of the question. It is happening. So we shouldn't. We shouldn't assume we could get away with it. We should be doing our due diligence and finding a way of complying to the best of our ability, depending on where our audiences are. So for me, I have a global audience. Therefore, I'm now thinking, there's probably a bit of research I need to do, because I know I have people consuming content from California. So what am I doing wrong compared to the EU, etc.?
Bit of a plug. We have a really extensive health section, and if you're doing research, we have a lot of information there.
See what you did there. Well done.
To help you figure out what applies to you and stuff like that. Absolutely. But yeah, I mean, the point is it's always better to err on the side of caution. Obviously, if you have like some kind of solution, not just plugging ourselves, or whether it's a lawyer or whatever, that has like a complete approach, especially if you have a global site, that's something good to do as well. In terms of the fines or the measures, countermeasures, fines are not the only thing that can happen to you, and not always the worst. Like there's cases where if let's say there's a complaint and the Data Protection Authority gets it, and then they do an audit and they check your processes, and they notice that your entire email list that might be like 5 years old or whatever has been collected in this incorrect way, you could be faced with like having that entire list invalidated and being blocked from using that data, and that's incredibly valuable.
Stop it! I'm having nightmares. I'm just like
having panic attacks, preacher.
I've been like, it progressively escalates, but I'm sure. I mean, I've not said much since the beginning, because I was like, oh my god, it's getting worse and worse. But I am sure that Abbie will show us how to sort it out, because stay tuned,
because we're
guys,
freaking out too.
Stay here, because she's the knightress in shining armor. She is. So I think we want to get to that place where you show us how to do it.
Yeah,
because,
I mean, guys, don't panic. I think that the major thing with like these laws or whatever, it's a mindset change, which is why it feels really like tough at the beginning. But with a few principles in mind, you can just set up your processes where eventually, you don't have, you should always evaluate, but it's not like a crisis. Right, so don't worry, we're gonna get there.
Yeah.
And just really quickly, I guess everyone else would have read this by now, but it should also include you should have your effective date of the privacy policy. You should disclose how you respond to do not track requests or signals from web browsers. So this is under CALOPA, and a few more, which in our documentation section on our help, that's totally free. We have detailed information, everything, in case you want to understand. So now we're looking at the California Consumer Protection Act, and that's the one that sort of that was this year. So it was all, all the talk of the town and so on. And basically, it gives users more additional rights, such as the right to be informed, the right to access information, which is kind of a little similar to the GDPR, that you've collected about them, and also what's really relevant to marketing. And I've highlighted it here because if you have a website, you're doing some kind of marketing, a lot of times, that is the right to opt out. And under the CCPA, users have the right to opt out of any processing that can be considered a sale of their data. And so this is the thing, sale is super broad, and it just means sharing for any profit, monetary or otherwise. Now, this has been under discussions, and I think, don't quote me on this, but I think I might have read or was told that there's further clarifications coming along, and maybe the definition of a sale might be adjusted, by the state of California. But as it stands right now, this is it. So this is one I mentioned earlier. If you're in the US, which is US customers don't think that cookies are not relevant to you, because cookies, these tracking cookies, they are sharing personal data with a third party, which it falls within the definition of a sale under this very broad definition with the CCPA. So what that means is you need to have a notice. I'm not going to super get into it, but you do need to also have a bit of a notice on the site somewhere informing users from California, hey, we're selling your data. You have to use that, you have to use the terms, but your data is being shared, it's being sold, and if you don't want this to continue, you can opt out. And then you have to have a link or a form or whatever that allows them to opt out of this. So in our case, this can be set up in various ways, because there might be situations where you're sharing the user data that doesn't involve an automatic script, right? You might be sharing it via an email list or something else. In those cases, you might want to set up like a contact form for people that click opt out, so they can say, hey, stop selling my data or whatever. But also in regards to the scripts, and in our case with our product, we sort of it's within our cookie solution product. So there's like a little switch that allows people to also kind of show this to Californian residents based on their location. And then it allows them to automatically sort of just switch off those scripts from sharing the information. So they essentially opt out. So, that's sort of how that would be done. So that's sort of one of the major things that the CCPA gave to Californian-based users. And also with the case of minors, they are granted the right to opt in. So if you're somebody with an app or a website that's targeted towards children, just know that you can't share their information in this way without first getting them to opt in. And if they're super young, under 13 or whatever, their legal guardian might need to do that. So these are some important things for the US-based people and people that have US-based users to keep in mind. Now, we sort of covered this point already, but this is just basically how to tell which laws apply to you and which do not. A general rule of thumb that we say is that you should comply with the laws of the country in which you base your operations, or the state in the US, and also those of the country that your site targets. Something to note here is that, there's some things that are they're in the law in theory, but they haven't been defined, and maybe you don't want to be that business that becomes the case law for it, right?
You don't want to be the test case, all that stress.
So what some people choose, I'm not saying you have to do this, but if you're absolutely not, what you're doing, it doesn't relate to people in the EU at all. So let's say you have a news website that's all about Kansas or something like that, right? Or it's just about Florida. Then you can just block people from and that's happened on some news sites, for example, that people from the EU or whatever, I wrote a nice message, sorry, we currently don't support the blah, 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 people from the EU, and then just kind of block traffic from that site, because the information is not relevant to them generally anyway. And then you kind of cut down, you just have to focus on your US compliance or Brazil compliance or whatever else. But maybe if it's absolutely not relevant to people from the UK, then from the EU, then that can be one solution. And also this is like, it's sort of indirectly related to this idea of data minimalization. Just process the data that you actually need. So if you're not serving me, I'm not getting anything from your site, I can't order your products because I'm in Europe, then there's no reason for you to process my personal data, which happens whenever I go on your site and I log in with Facebook and whatever. So it depends. If you're just like in e-commerce, you do ship abroad or whatever, you know, it's a huge market. So for many people, they don't want to lose that revenue. Even if they're just writing content, they have a blog, there's significant ad revenue to be made as well. And maybe they don't want to lose that and block an entire region. And in these cases, there are tools like ours, okay, that can allow you to apply the right laws or whatever to the right users. So that's just something to note. Also here, your legal documents need to be written in the same language as your site or app so that your users can understand them. So, okay, if you have a lot of users from Russia, but there's nothing on your site in Russian, they're just accessing it in English, okay, it's fine. You don't need to have your documents in every single language. But if you do have your site in a language...
That is a relief. That is a relief, yeah, for sure. So you bring, see, rays of light coming
little
in
tiny
for
bits
everyone.
Of hope. But I wrote at the bottom here, special considerations, GDPR, that was a bit of a note for me. I already covered the cases where the GDPR applied because I wanted to highlight that even if you're an EU company with only users outside of the EU, you still fall under the scope of the GDPR. And also if you're in the US with EU users, but also with the CCPA, there are a few, like I won't go into them here, but there are like a few requirements. It doesn't apply to every single business that has Californian consumers. Based on the requirements, it applies to quite a lot, but there are a few things that also need to be true for you. So we have this is completely free. We just did it for like convenience. We have a little quiz that kind of makes it easy for people to be able to tell if the CCPA applies to them. But of course, it makes sense to still understand the requirements yourself and check and see if it applies or not. I don't have my notes here, but it's something like there are like 3 requirements, and if at least one applies, then the CCPA might apply to you. So one of them is that you have Californian consumers, so it wouldn't apply to like B2B business necessarily, depending on how you process the information. And then also, like if you have a certain number of site visitors per month or something like that. So I don't want to give you wrong information just because I don't have these notes here, but we do have all of this available for anybody who wants to learn and understand about it. Now we've covered the compliance, which is like a mouthful, and it was quite a lot. So I just wanted to give a quick note because we did talk about protecting your business, and I wanted to do a special note on protecting your business. Now, first of all, everything that we sort of talked about with compliance is protecting your business because there are substantial losses, obviously, to be had from violating the law. But also, as we move into this era of like privacy awareness with Apple's like latest changes and so on with the operating system coming out, it's more privacy focused because consumers are beginning to expect more control, more transparency and things with privacy. So you can also face losses in violating user trust, right? By not complying with the laws you're supposed to comply with. More and more users are aware of what they are. So that's one way that you're protecting your business with compliance. But the special note here is that all of the things that we've talked about and the solutions and the ways to comply, it applies to sort of like protecting the user and their information as well. Terms and conditions are like the one document that's completely focused on protecting the business, which is why I thought it was important to highlight. So it can be sometimes legally required, in a lot of cases not, but if you have an e-commerce store, there are some disclosures that you need to make legally, whether it's things like withdrawal rights in the US, withdrawal rights in the EU, and also some in cases in the US, return policies and various things. There are some disclosures that are legally mandatory once you're selling, and these typically go in the terms and conditions. So that's when they're legally required. In a lot of other cases, they're not technically legally required, but they help you with handling user-related issues when they arise and preventing it in the first place. And basically terms and conditions, because they're everywhere, but a lot of people don't really understand what they are. They're contracts. They're legally binding agreements between you and your users. And it allows you as a business, as a site owner, to set your rules on how people access and use your service. Okay, can they share information on your site? Under which rules? You know, can they share it with third parties? Do they need to link back to you if you're producing content? Different things like if people are allowed to create accounts, what would constitute determination of an account? If they abuse the bandwidth of your site, if you can delete their account, if they're entitled to getting their membership feedback, like, you know, all of these different things that people can challenge you in court. With your terms and conditions, you're sort of preventing a lot of issues, because without this document, it's up to the courts to decide, right? But if you do have it on your site and it's like it was available on the site to the user, they agreed to it when accessing your, you know, when using your site, if they do try to bring you to court, it gets shut down really quickly, because you can point to the contract and say, well, actually, according to our terms, you violated it. I had every right to cancel your account, or you didn't have a right to do this. You're not allowed to use this language on the site, this kind of thing. So just a really quick overview of this, because it's a really quick shot, because usually we do a whole separate webinar just on terms. But really quickly, if you're thinking, okay, if I'm creating terms, what sort of things do I need to think about in terms of prevention and stuff like that? You want to have your disclaimers, limitation of liability. If you're selling stuff, things like shipping, processing, and return rules. Now, just to reiterate, terms, it's not with privacy compliance. This is something that's separate. It's again on the rules of using your site. Things like account creation, termination, conditions, what you term accepted behavior, copyright, and also setting your law of governance, which is really interesting and nice. Let's say your company is based in Tennessee and it has really favorable laws for something related to your business, even though you might have users in like another state where there are more stringent laws, or the laws are different or whatever. You might choose to set your law of governance as being Tennessee, where you're actually based, so that you have more favorable conditions. So this is something that terms and conditions can kind of allow you to do. However, they can't be used to get around like the law, like this TCPA, the GDPR, privacy laws and stuff like that. They have to work within the realm of applicable law. So that was the special note on protecting your business with terms. So that was a whole lot. I'm just going to go really quickly into practical ways that you can comply. And so just as an overview, and then I'm basically going to do this with a demo website to kind of get you into the mindset of what you should sort of think about when you're assessing your own website. Now, first of all, you want to assess and identify your processing points on your website, also in your business. I put a star here because, you know, some businesses process things offline, right? Maybe you don't just have an online business, or maybe it's interrelated with something else. So you need to actually, laws like this, it requires a mindset shift where you need to actually think about your processes and then identify each point where you might be interacting with personal data of users. And there are a few tricks that you can use to get your mind going in the right direction here, and we're going to go through that in the walkthrough. Another thing is to practice transparency, and this is not even like a nice to have, it's just legally required. So you have to make the relevant disclosures, keep them up to date, and you must also clearly identify yourself. Now, in terms of relevant disclosures, like for your privacy policy, I'm going to go really quickly here because we're running out of time, which is for the basic disclosures that your privacy policy should probably include would be things like who is the app or site owner, what data is being collected, how it's being collected, what's the legal basis for the collection if something like the GDPR applies to you. What purposes are you collecting the data for? Categories or sources from which you collect the personal data. This one's more related to the CCPA. Which third parties you're sharing this data with. Any details related to the cross-border or the overseas transfer of data. So if you're using servers based in, you're in Europe, you're using servers based in the US or something like that, or in a country that might not be outside of the EU. Does that country, is it considered to have an applicable level of protection, like an adequate level of protection, different things related to that. Also, any rights that the user might have, they need to be informed of that. So they need to know they have the right to have their information erased, which is granted under both the GDPR as well as the CCPA. So that's important to know. Users can say, I want you to delete all the data that you have on me, more or less. So they also need to know all the rights they have. And then you should describe your process for notifying users of any updates to your privacy policy and the effective date of your privacy policy. So that's just sort of a basic idea generally of what you want to disclose in your privacy policy document. Serious business, but anyway. So about the mindset shift, minimalize your data usage, which just process data, only process data that you need. A bit of a typo there. So that's really important. And that kind of solves, it's more of this is a little bit more of one of those long-term things. It prevents a lot of drama overall in terms of handling data correctly if you're only handling just what you need for your actual processes. And a lot of people don't realize that they might be processing tons of extra data that they don't need. So it's good that ties back into assessing and identifying your processing point and being intentional with the data that you process. This is a really practical one. Have a content management platform on your website if you have EU or Californian-based users. So the content management platform would be something like that, the cookie solution, or that thing that blocks the scripts until you get consent from the users to run cookie scripts and track them. In the EU, in California, content management still comes into play because people need to be able to opt out. So having that notice that says, hey, we're sharing your information. If you want to stop this, click this link, do this, do that. So have a content management platform. You can build, if you have a developer, try to build your own thing or whatever, but you want to make sure that you are, if you're monetizing from ads, make sure that it's, it's using the transparency and consent framework.
So Ubanda would provide that, the consent management platform. That's what Ubanda does.
Yeah, that's so we're a content management platform as well.
Okay, I think that we really can't wait to see the demo where you show us how amazing Ubanda is and how it takes care of everything.
The thing is, guys, I'm sorry, but with the time, we're actually the walkthrough is more of showing you how to assess a website.
Oh, that would be great. Yeah, sure.
Of our solutions. But the thing is that if you go on our website, you can see really easily, like on the landing page, there's a nice little video that shows you exactly how everything works. But basically, your content management platform handles this. Ours, we're a registered CMP, so content management platform with IAB. So we work closely with them as well. So you know that your content that you're passing is going to be accepted, it's correct, your ads are going to run properly and all of that stuff, in our case as well. So also you want to get opt-in consent for EU-based users. And I included this as a separate point because if you have mailing lists, and I'm going to explain it better on the walkthrough, but if you take email addresses for mailing lists and stuff like that, or even you have people sign up for an account, don't just assume that because they signed up for an account, it means that you can send them marketing emails. They need to opt in for that. It doesn't have to be complicated. You can just add a little checkbox that allows them to click it and say, yes, I want to receive like this kind of communication. But this box should not be pre-ticked. And I'm going to show you a little example now, actually. And then the last one is to make sure you keep the legally required records and proofs. And this is one of these things that people make a lot of mistakes with. They don't realize that under, especially the GDPR, you're legally required to have proof that you're doing things, especially with consent, you're collecting it in a valid way. Without this proof, you can face the situation like what I described before, where you might be audited. They're like, where's the proof that this was collected correctly? I don't have it. Okay, I'm sorry, you can't use this list. I'm not saying that they're absolutely going to handle it in this way, but these are the kinds of risks that it's explicitly stated that you do need to have records and proofs. And we also have a solution that automatically does that on a technical level, records the proof of consent. It ties into your forms and does that. So this is a visual example of what it means to get opt-in consent for EU-based users. So it's just kind of showing you the wrong way and the right way, because I wanted to go over some common mistakes, and this is a really common one, where people just lump together terms and conditions with the contact permission, and then I agree to terms and conditions, and then the person's getting contact permission as well. It's incorrect and not valid consent. So this is the way that you want to do it. You want to make sure the terms and conditions has its own little separate checkbox. It's like, okay, I agree to the terms and conditions. Now, having them agree to the terms and conditions, it's a nice to have for your own proof to show that they definitely saw the terms and conditions. So most sites, even when you're signing up Google or creating an account or whatever, you have to say that you've read the terms and conditions. Otherwise, you could probably just have it on your site. But then if you are legally challenged by a user, you want to prove that they read it, it was accessible, it's a good idea to have a checkbox like this. And then you can see the contact permission has separate information. It explains what each contact permission is for, and it allows the person to opt in by clicking the checkbox to agree. And that's it. I mean, it's not a huge difference, but one is compliant, one isn't. And this is a visual example of what sort of a content management platform's interface might look like. So this is ours. So this is not what the user sees right away. They see like a little notice or a banner on the site. You know, the site uses cookies, blah, blah, blah. Click here to learn more. And there's a learn more button. And if they open that, they see this little modal that allows them to either reject or accept cookies, to see the full cookie policy, save and continue, go back to the site, whatever. And I'm sure most people have seen them on a lot of sites, especially if you're based in the EU. So this is just like a quick example, because I'm using these words. I wanted people to understand what I meant by this.
So the thing is that another side effect of all this, apart from the generalized panic that's running through all of us, it's the death of UX. It really is. I mean, the website experience in 2020 is awful, and you can't blame anyone for it. What can we do? We have to have this, don't we? We don't. The visitor, upon hitting our website, needs to see all this. Otherwise, we're not compliant. That's basically long and short of it.
And it has to be, yeah.
And basically, I bet that all of us, what we feel when we see this, we just feel, yeah, whatever. And I personally, I would rather, I mean, I know that it's there to protect us. And yet when I have to suffer through it and I have to click like 3 different windows that, and not everybody puts them correctly. So sometimes they don't even shut. It's just a nightmare, especially on mobile. And even though it's there to protect me, at the same time, I am thinking often it was better when you didn't protect me, because I don't feel protected anyway. Yeah, so this is, sorry, just something that...
No, it was actually a really good point. The thing is that, I mean, a lot of this also falls on maybe the software being used, but also some of the choices of, like, there's some that's unavoidable, but also some of the choices of how you choose to implement it, right? I mean, I don't think, in my opinion, I don't think it's useful to frustrate your user. So like I saw that there were some websites that were doing this approach with like 3 or 4 windows to just kind of eventually exhaust the person into clicking accept all, which I personally think is a bad approach in the end, right? It's you're indicating that you don't care about my experience on your site, and you're making it really difficult for me to click no by making me have to go through 5 windows just to change what I want you to track. Like, maybe I'm okay with you, the strictly necessary stuff. Maybe I'm okay with measurement, but I don't want personalized ads. Or maybe I'm okay with the personalized ads. You know, it just kind of depends. Obviously I can't give exact numbers, but in our case, surprisingly, the consent, well, not even surprisingly, because we've been in this space for a while, the consent rates are quite high. Most people will give consent, and most people prefer to see an ad that's relevant rather than some random thing that has nothing to do with them. So I think that since we can't make it go away on the business side, we have to get into the mindset of working like with the users, because in a lot of cases, they want the same thing. They want your service. They want you to still be able to provide things for free, and they understand that this might work with ads. You know, so just being transparent about how you're going about it, what it's going to be used for, can go a long way. And of course, the way that you choose to set up your banner, it doesn't have to be invasive. It just has to be conspicuous. Legally, it has to be conspicuous, which means visible. It can't be like invisible blending into the background, like you have to squint to see it. But it doesn't have to be like a loud orange box in the middle of the screen either. So, you know, there are some options there, and we try to make it as easy as possible on our side to kind of just get this done on both sides. And that kind of ties into our compliance solutions. So this was a really general talk today because we sort of covered a lot of things to just inform people. And I didn't really speak about any specific solution, but it's in line with what we do because we do 360, that's the marketing term, 360 solutions. And what we try to do is compliance solutions for all aspects of the law, and also for multiple countries, multiple legislations or whatever, to make sure that if you're a global company, you can just kind of, you don't have to do like 5 different companies. You have one dashboard, access to all the products, and you're able to apply it, set it, and forget it where you can, and that sort of thing. So first one is a privacy and cookie policy generator. And this allows you like within minutes to generate a privacy policy that includes all of the stuff that we mentioned. So the nice thing about understanding about the law being so extensive is that you know what needs to be declared. So all of our text, it's actually written by our lawyers, and we have an international team of lawyers. And we write these clauses and we separate them into this thing called services. And basically services includes all of the disclosures that you need to make for each, let's say, aspect of processing in one. So let's say you have a Facebook login button, you go into the generator and you just click on, you type in a Facebook login button and you add that to your privacy policy. And then it's gonna add like this nice little clause that identifies Facebook, links to their privacy policy, talks about the data that's being processed, talks about why you're processing it, because if you have a login button, it's for a standard reason, and all of that stuff. And then it generates it into a nice document that's, it's very light and fast, but also it's visually appealing because the law says that, you know, the document shouldn't be super overwhelming for the user. So we have like a shortened version where people can get an overview. And if they want more detail, they can always just kind of click on full policy and then get all of the legal details. And our solutions are also used by lawyers for, you know, their clients as well. And for some of our enterprise clients, their legal teams sort of just work with us and set up with our software to generate these documents because they're auto-updating. So you don't have to go in every single time when the law changes, we auto-update. Next is a cookie solution, and that is that consent management platform that I mentioned. I sort of went through already what that does. So if there's a banner, it blocks the scripts, it allows you to collect the consent, and so on. And it works for the GDPR, for the CCPA, and so on. Also, there's a terms and conditions generator, which does the same thing as a privacy policy generator, but for terms and conditions. It's super duper powerful. I go on at length about this product. It took us forever to put it together, just because you go across multiple legislations. You're talking copyright law, you know, age, commercial law, all these different things. It's more or less, it's created in the same way, lawyers, written by lawyers and so on, so that you can generate your terms and conditions. Everything is fully customizable, and you can also write custom clauses if you need to. Our consent solution allows you to maintain those records and proofs that I mentioned before of your consent automatically. And the internal privacy management allows you to assess your site, keep track of your own processing internally, and also maintain these records of processing activities that are legally required under the GDPR. So it was a mouthful. Now we can jump over to this sort of live walkthrough. And hopefully get you started on your way of understanding how to assess your website. So I'm going to go ahead and switch windows now. And guys, if there are any questions, please feel free to ask me. I'm just hurrying because I'm not sure how much time we have left, and I didn't want to drag on.
We are 2 minutes from the end, so you've been amazing. So let's do the quick walkthrough, and then what we will encourage people to do is to circle back and ask further questions in the comments, and obviously we can all jump in and help.
Your
them
flow
out
was
there. So I'll throw you.
So amazing that we didn't want to interrupt it.
I'm so sorry.
We didn't want to interrupt all of the goodness.
Oh my god! I forget all of them.
So now you know you definitely can't speak for 30 minutes on this. You need more time.
Okay, so basically we're on this e-commerce site. I just kind of chose this because it's a demo, by the way. This is not someone's real site, but it's just so that you can get an idea. So if let's say you're assessing your site, and this can apply for any kind of site. The number one thing I would say, I've broken it down into sort of like 3 basic points again, this is to begin your assessment. It should be detailed eventually, but the first thing you want to think about is your input points, right? Your input points. So where are you getting like your feedback from users? So things like contact forms, sign up forms, payment forms would all be processing points, obviously, because these are points where people are inputting information. So that would be something to consider. So on this website, just try to scroll down to the bottom. You can see here there's like a subscribe for email. Also, if we go all the way to the top here, we go on contact. Already, this is another location where people can put in their information and stuff like that. So in your privacy policy, you want to include that you have a contact form, and we have like the little service for that, where you just click that contact form. But also, don't confuse your contact form with just your newsletter. It's 2 separate things. And you're processing data for different purposes. Here, it's to contact the person to receive their requests. Here, you're looking at sending them communications about your products, about whatever. So you want to make sure that you include these separately and don't get those confused. Another thing just to add here is you also want to make sure that you're being clear about what they can expect with your communications. Another thing on the topic of input points, this is, well, actually this sort of, we're looking at tools that can also help with this kind of input that the user puts in, or actions of the user. And right here, you can see that there's like a like page. There's a Facebook widget here. So you definitely want to make sure that you're declaring that as well. And then, so that's really quick because we're going fast. So now we're looking at this here, right? So obviously it takes some kind of payment. So that brings us to the second thing you want to consider, which is revenue sources. Because obviously if somebody is, if they're paying you, they're sharing like details with you, aside from their shopping, maybe financial information and so on. And this might also tie into tools that help you with this, like PayPal. So if you're using PayPal on your sites integrated, you're probably going to want to add that to your privacy, or not probably, you have to add it to your privacy policy, stating that, we share data with PayPal, we use them for processing the payments, with Stripe, with whatever you're using. Another thing here is that with this mailing list, so again, with input points, if you're using MailChimp, for example, or some kind of software to manage this, you also need to declare that. So not only are you declaring that you're processing, but you're also sharing it with a data processor or company that's handling the user's data on your behalf. So that's something that you want to consider. So all of these are things that will come up if you're looking at your site and you're going, okay, I'm looking for input points. Where are the input points? Now, there are some input points that are not so obvious. And these are, you can begin to think about them by thinking about where you get feedback from your site. So I actually have some little things here. So where you get feedback from your site, it might be things like analytics or hotspots or something like that. So a lot of people don't even think about analytics, but yes, you do actually have to mention that as well. You had a question?
And another thing that people don't think about is like fonts.
Yeah.
If you use a font service such as Typekit, you need. You probably need to do it with Google as well. That needs to go in as well. That's why, it's so great to use Ubenda, because it's so granular. It lets you do all this, but at the same time, because it's so granular, it slightly makes you go, what? So this is super useful because it points out
with
what
that
we
said,
should
it's
be
actually
looking
going to
for.
tie into like another point of how you can tell. So we do it super granular because like we have developers and lawyers and so on using the software, but we've been trying to make it like even just easier and easier for people to be able to use. It is quite easy to use, and we have our chat like staff that will basically set everything up for you. But we also have this feature that's called, since you brought it up, it brings it in. We have this scanner feature within the generator now. So actually all of the things that I'm talking about, it makes quite a lot of it easy. So you just, let's say you have a free account, or even with a free account it works, and you put in your website, and then it does a scan of your site. If you already have one of our privacy policies on your site, it's going to compare the services that are running on your site that it finds with what's in the privacy policy, and it might say, hey, we think you're missing this. If you don't have one of our privacy policy on your site, it's still going to scan and tell you, okay, these are the services that we've detected that are running on your site, and we suggest that you add these services to your thing. So we're actually making a lot of big strides to just make this as easy as possible. But
that is super helpful for all the non-techie WordPress users, by the way.
No,
interrupt.
please, absolutely. And we also have the WordPress plugins available.
Also, for those who don't use Ubenda, they do amazing things, such as sending you an email saying, "Oi, you've got this plugin activated, but it's not in your terms, or it's not where it should be. We suggest that you actually amend your terms." And I'm like, thank you. So that's privacy policy. Thank you. So that's how great it is.
No worries, guys. I'm afraid I'm going to have to cut us short because we are running out of time, especially with the hosts, etc. So what I really quickly wanted to do, Abbie, was show a scan that I did whilst you were talking, exactly what you were saying. So these are the results of my scans on agencytrailblazer.com when I was seeing whether or not I should be what I should be covering on my privacy policy. And it said obviously Google Analytics, but it also did highlight the fact that I do have a pixel, which also has all sorts of other elements. So this was ridiculously helpful for me, all sorts of things that I would not have considered. So I have downloaded in the past a privacy policy template. I've then gone, what do I use? Google Analytics. Yeah, I'll throw that in, and then not thought any further. So I'm really impressed with what people can do with regards to scanning.
You said that, and I wanted to say that now we still send the email, but now it shows up actually in the generator. So you can see right there which ones.
So it showed me.
I mean, the generator is incredible, guys. It really is incredible. We need to have you back on to show it to us. Sorry, Lee.
Yeah.
It's all right.
Sorry, Lee, to interrupt.
No worries. It actually showed me what I could then add, and then I could then export my privacy policy, which was phenomenal. But
guys, I just before we wrapped up, I just thought of something that I was supposed to mention earlier. That's really important to US-based users, and since you have a large US audience, I wanted to touch on that. And it's just that there's this thing, we have it highlighted now on our site as a news piece, but it's a Facebook limited data usage, which they've sort of implemented. So if you have Californian-based users, they've had this sort of aggressive setting where it does like limited data processing for these users. But in some case, like the point is that if you're not passing the data yourself to Facebook, their approach can be really aggressive, and you might end up with like reduced reach or whatever on your ads. So it's something to be aware of. And our solution now supports passing the correct geolocation data to Facebook. So just in case people, because a lot of people, they use the Facebook pixel. When you mentioned it, I thought of it, and it's something that's quite recent. And we have some information up about it. If the first time you go to your site, you'll see news on top, and then we have a link to it. So that's it.
No worries, just removing that. So that's at the top of ubenda.com. Folks, if you need any more information, you can visit ubenda.com. That's iubenda.com. The link is on the screen. We will make sure that we post that in the notes as well of this show. Abbie, it would be awesome if you could also keep your eye on the live, because I'm pretty sure there was a couple of questions that did come in. If you could answer those. What I would echo as well what Peach said. We would love to have you back on, because clearly an hour wasn't long enough. We'd love to have you back on if you would come on maybe in a few weeks' time to carry this on, because I feel like we've scratched the surface. We'd love to see what Ubenda does in more detail. And I know I've got more questions, which unfortunately we don't have time to ask you. So all that's left for us to do is to quickly go around the table to say how everyone can connect with us, and then we will say goodbye. So let's start with Jan.
Yeah, the best place to connect with me is my Facebook group, WP Mastery.
Abbie.
The best place would be on Twitter, which is just like twitter.com, Abbie M. Clement. So that's ABBIEMCLEMENT on Twitter. And
Peacher.
On Twitter, I am Peacher. I mean, how easy is it? PICCIA.
Nice and easy. And if you go to Lee on Twitter, you'll find a jeans company. So go to leematthewjackson.com or agencytrailblazer.com. Abbie, thank you again for showing up and offering so much value and giving us so much information.
Amazing.
That was amazing. We can't wait to get you back on. If you'll have us, we would love to have you back on to carry this conversation. So all that's left for us to do, folks, is to do that wonderful awkward wave until I decide to end the broadcast. Cheerio.